Good morning. Thank you for joining our live webinar. Today's topic, child custody and parenting rights. A very interesting topic, one that I obviously generally deal with. However, there seems to be some confusion regarding parental rights. Does the mother have more rights? Does the father have more rights? Do they have equal rights? When does one party have more rights over the other, over the child compared to the other parent? So today we'll try to tackle that specific issue, that specific topic, and the topic is quite diverse. If you have any comments or you'd like to pose a question, please do so on the Advocate Mohammed Abdul Facebook page. We are streaming live from that page. You might be watching this video live from a different Facebook page. However, the Advocate Mohammed Abdul Facebook page, that is a page that I'm looking at. And if there are any questions, I will take the questions there from. Okay, everyone, good morning. Thank you very much for that comment, and maybe tell me where you're from. That's also good to know where people are watching this video from. There are a few questions that people posed to me prior, that was emailed to us, and I thought it is best to deal with those questions live as opposed to me emailing the person back. I do email the person back, however, deal with it live as well, so that all of us can benefit from that. We can all learn. The first question, the father of my child is allowed to have contact with our child every second weekend and one evening during the week when he does not have weekend contact. I'll explain that shortly. This is in terms of a parenting plan that was made in order of the High Court. The father remarried and now wants to have contact 50-50. I do not know what to do as my son does not want to share contact. Any advice? Okay, so the way contact here works is as follows. The father would have contact Friday, Saturday, and Sunday, drop the child on a Sunday, and obviously he will not see the child the next weekend. Then the following week, you will see the child during the week, and then his weekend contact will continue again. So the idea basically is that the gap between contact is not that long. So he has a child this week, he does not see them for a few days, and before he has contact again, he will see the child again during the midweek. And this person specifically stipulated that contact is in terms of a parenting plan that was made in order of court that is allowed. So the parties entered into a parenting plan with a professional person, either an attorney, an advocate, office of the family advocate, a social worker, a psychologist, someone that can assist them in drafting a parenting plan. As I always mention, each family is different, all circumstances are different, and therefore a parenting plan will have to be unique to every family's situation. So they were assisted in drafting a parenting plan, and once a parenting plan was signed, it was made in order of court. One of the parties made an application to court to have the parenting plan be made in order of court. The one advantage of having a parenting plan made in order of court, if one parent does not adhere to the parenting plan, it is a court order, you're in contempt of court. Especially if the parenting plan deals with maintenance provisions, which is a good idea to include it therein. Therefore, if a party does not adhere to those maintenance provisions, the other party can immediately go to court and lay a complaint of non-compliance with the maintenance order. And it makes logical sense because if you do not have a parenting plan that has been made in order of court, you are hoping that the other party will comply with it. And most of the time they do comply with it, but sometimes they do not comply with it. And then you have to start this whole procedure over, approaching the court and having it made in order of court. Okay, so I unpacked that first 2 points, and the second point was the father is exercising reasonable contact every second weekend and midweek contact. Now the father remarried and now he wants to have contact with a minor child every, 1 week on, 1 week off. Share contact 50-50. How does that work? Basically, you choose a day in the week. It's either Monday morning, Sunday evening, or a Friday. Depends on the circumstances. It's not usually in the midweek because the children goes to school and you do not want to disturb that. So if it's a Monday, the one parent might start exercising contact from after school on the Monday, collecting the minor children from school, collecting them, taking them home, the next morning taking them again to school. That follows for the entire week, the weekend as well, the Sunday evening as well. And the Monday morning, that parent will drop the minor children back at school with clothing, whatever the case may be, whereby the other parent will collect the minor children again from school the Monday afternoon. And that process continues. So that's how shared care generally works. If it starts on a Friday, basically one parent will have the minor children the entire week, from a Friday till a Friday, maybe till after school, collect the minor children after school, and the other parent will collect the minor children from the parents' home after school, and that cycle will begin. So that is shared care, how it generally works. Sometimes if the child is very young, it might work differently. If the child is not school going, it might be 4 days, 3 days, 4 days, 3 days, 3 days, 4 days, depending upon the parents' circumstances. So here we have the situation. Question number one. Father is exercising contact in terms of the parenting plan, which was made in order of court. He remarried, and now he would like to have contact 50-50. The child is saying the child does not want to have contact on a shared care basis. The child is happy with seeing the father every second weekend and staying with the mother during the week, being his primary caregiver. Any advice? Because the parenting plan has been made in order of court and one party wants to relook it, I would strongly advise both parents to cooperate in this regard. They need to have this matter properly assessed and not think about court at this point. They need to discuss it properly and determine what is workable. Why does the mother think it's not workable? Why does the child not want it to believe it will work? Why does the child not want it to be implemented, and so on? They should try to do that between themselves. But if it cannot be done, if they are, on two opposite sides of the plank, they need to seek the assistance of a professional, someone that understands the law, someone that is not in favor of dads or in favor of moms, but understand the dynamics of these type of matters, that every family is different and what applies to one family does not necessarily apply to another family. Then they need to consult with this person, maybe a mediator, a child care expert, to assist them in resolving this issue. The professional person might want to consult with the child and speak to the child and ask the child, what is the child's view? Why does the child not want to exercise 50-50? Or why does the child believe it's best that contact remain the way it is? Find out what the father says, find out what the mother says. Let them engage with each other. And hopefully after that exercise has taken place, the parties will resolve this matter. One or two things may happen. The mother might see, the father makes sense. It might make more sense for the father to have the child 50-50, and the mother might benefit from that, because she will have more time for herself. I do not know. And depending upon the age of the child, etc. Or the father might say, you know what, I was being a bit, ambitious here. My new wife was the one behind this. It is better that the minor child remain in the primary care of the mother, and I continue having contact every second week in midweek contact. And generally, it is half school holidays, so the mother can focus on the child's schooling, well-being, and so on. I hope I answered that specific question well enough, and the person that posed that question is watching this video and would be able to benefit therefrom. Let me just conclude on that point. If the party, let's say the father under these circumstances, he's not happy with the process, he's still adamant that he wants to have shared care, he will have to ultimately approach the court and make an application that the order be varied, the parenting plan be changed to incorporate 50-50, or the parenting plan should fall away and 50-50 be implemented, shared care. Obviously, I'm presuming, or I'm guessing, that in the specific parenting plan there is no provision made for alternative dispute resolution, or what can the parties do should they want to change the parenting care provisions before going to the court. But ultimately, if the matter cannot be resolved and all avenues has been exhausted, the court will have to be approached, and the court will make a decision as to what is best in the minor child's life. Going back to our comment section, let me see what's over there. Okay, the person mentioned here, I'm watching from Pretoria. Please explain the new bill passed giving unmarried fathers equal rights. I am not familiar with any bill that has been passed regarding giving unmarried fathers equal rights. At this moment, I might be outdated regarding the law. If I do come across something like that, I will obviously do a webinar regarding that. But thank you for bringing that to my attention. At present, unmarried fathers, they acquire parental rights and responsibilities in terms of Section 18 of the Children's Act. So by default, if you're unmarried and you were involved in the child's life, automatically you acquire parental rights and responsibilities regarding my children. If, however, you are married to the mother, automatically you have parental rights and responsibilities. The reason for that could be a father could make a mother pregnant, one night stand, to use a silly example. He goes missing, comes back 10 years later. Can he say, I'm the father, I have parental rights, I automatically have equal rights because I'm married to the mother? No, he cannot do that. The mother most probably moved on to the life. The child moved on to the child's life. The child got siblings, step brothers, step sisters, as the case may be. The other father out of nowhere came 10 years later and says, I'm unmarried, but I have equal rights. That might not be applicable, but however, if he was involved with the mother, with the child and the mother, he can acquire those rights. Even if he comes back 10 years later and now he says, I made a bit of a mistake, I now want to be involved in the child's life, the court will have to look at what is best for the minor child, and more than likely the court will phase in contact if it is in the child's best interest. I hope I answered that specific question. Okay, let's go to question number 2. We're doing good with time. I am currently pregnant and expected to give birth in August this year. The father does not want to tell his parents that she's pregnant, of course. He says that if I tell them, he will dispute paternity. What are my rights? Now, this is very challenging and difficult for me to deal with issues concerning minor children when it comes to pregnancy, when a mother is pregnant. For starters, the child will be born in a few months' time, and that is the best time to resolve any legal issues, not now. If the father says he is disputing paternity, how do we determine paternity, and what's the purpose behind confirming paternity at a specific point? Putting the mother's body and the child's DNA and so on in jeopardy, and doing these specific tests. Is it necessary? Should it be resolved while the parties are pregnant? While the mother is pregnant, or would it be best to be resolved once the child is born, and then we can resolve all these issues, child maintenance, parental rights, and so on. So that's my challenge when people consult with me, and they consult on a regular basis, and I give them a ear, and I advise them as best I can. My advice generally goes as to once a child is born, where are we going to with this? For example, regarding child maintenance, if the father does not want to contribute towards the birthing expenditure, fine. Hold those receipts, keep those receipts, those expenditure. Once the child is born, then you can approach a maintenance court, and the maintenance court can make an order that the father should contribute towards those past birthing expenditure. And I do not think it's a good time for parents to deal with parental rights issues while the mother is pregnant with a child. She needs to focus on the birthing, and once the child is born, and then we can deal with the matter. Because if the child has a name, an ID number, and so on. If you look at the maintenance application form, it specifically stipulates child's name, date of birth. You cannot approach a maintenance court and stipulate, I would like to claim maintenance for a child that's not yet born. What's the child's name? We do not have that. I'm just being facetious, but that's a practical issue. And the father disputes paternity. What happens then? We'll have to wait till the child is born, and then we can deal with the matter. Okay, getting back to the question. What can the mother do? She will have to wait till the child is born. That's the best thing to do. Once the child is born, then she can start enforcing the minor child's rights and her rights, of course. She can approach the maintenance court and advise the maintenance court, this is the father of the child, he is disputing paternity. What the maintenance court will do is they will ask the parties to do a paternity test, whereby they will take some tissue from the child, from the father, from the mother, whatever they do, and they will try to determine paternity. If the father is a father, the matter will proceed. If he is not the biological father, the matter will come to a dead halt and the matter will be removed from the roll. She can, as I mentioned early on, she can proceed with claiming maintenance going forward, and at the same time, she can request birthing expenditure reimbursement to a certain portion thereof. She has to keep receipts, etc., and that's what she should do. Regarding care and contact, I have a problem with the law. The law cannot force, unfortunately, the law cannot force a father to love his child or to be involved in the child's life. Therefore, if the father does not want to be involved in the child's life, there's not much the mother can do regarding that. However, she can always enforce her maintenance claim or the child's maintenance claim against the father at any time, despite him not wanting to be involved in the child's life. If the father wants to be in the child's life and wants to be involved in the child's life, the court can obviously not the maintenance court, but the children's court or the high court can deal with that matter, and they can resolve the issue regarding that. I hope I've answered your question for the unborn child. I hope you have a good pregnancy and the child comes out healthily and the father gets involved in the child's life. There might be a lot of heightened emotions and so on happening at this time. A lot of things are taking place. I do advise you that once a child is born, soon thereafter, a few weeks after, once you're stable, then approach your father and ask him what is his commitments. Is he going to support the child? Is he going to contribute towards the expenditure of the child? Does he want to be involved in the child's life and so on? Know where you stand, and then you make a decision take from there. We have additional comments. Thank you for your comments, and there's quite a few. A live comment on Facebook Live. Can the mother withhold access if the father hasn't paid damages? Does customary law make provision for this? So, what happens in customary law, I'm not an expert regarding customary law specifically. You have various aspects or various denominations of customary law in South Africa. Nonetheless, should a gentleman make a lady pregnant, he may be asked to pay damages for that. And if that is the case, the question which is being posed live, can the mother withhold contact to the father before he paid damages? And the quick answer would be no. Maintenance or damages and care and contact rights are two separate issues. They are not connected. They might play a role in determining one over the other. For example, the father says, I'm paying my child maintenance, I'm doing whatever I can, but the mother still does not want me to have contact with the child. The courts will still have to deal with the matter separately, but it shows good faith on the part of the father, compared to a father who does not pay any child maintenance. He doesn't want to pay child maintenance and now he wants to be involved in the child's life. The court ultimately will have to determine what is best for the child under all circumstances. Don't get me wrong. But the bottom line is, if a person cannot afford to pay child maintenance, that doesn't bar you from having contact to your child. I think that's the way I'm going to with this. And if a party is extremely wealthy and he does not want to pay child maintenance, you cannot refuse him contact. Your job is, as a mother, is to go to the to the maintenance court and claim maintenance from them. It's two separate issues. And at the same breath, if a father pays for all the minor children's expenditure, but the minor children will not be best cared for should they be in his care, then under those circumstances, he will not get contact rights or certain type of contact rights, although he's paying for everything. So it doesn't mean you are paying for everything regarding the minor child. Automatically, you will have more rights as opposed to a party who is paying for less. So I hope that answered that live question. Thank you very much for that. Okay, I see we have an additional question live. I'm happy of that because of that. Okay. Also, can one file for an interim order while waiting for a DNA test? What happens is the DNA test stops everything. There's a dispute, there's a potential dispute regarding paternity. And until the paternity issue has been resolved, the court cannot proceed with any order being made. For argument's sake, let's say you're asking for a sum of, let's say, I'm using a silly figure here of 100 Rand per month for the minor child, but the father's disputing paternity. Now he pays 100 Rand per month for the next 2 months because that's the next date the court has available to see the parties to read out the results, and it comes about that he is not the biological father. So he paid this money to a child for a child that's not his, and he disputed paternity from the word go. So until paternity is finalized and resolved, the maintenance matter cannot proceed. And it makes logical sense. It will cause too much problems should a maintenance matter proceed if paternity is in dispute. And now the last question number 3. 2 weeks ago, the father of my child, out of nowhere, demanded to have contact with his child of 3. We were never married and ended our relationship soon after the child was born. That was last I heard of the father. The lawyer says the father has a right to see the child. What should I do? The child does not know who the father is. That's a typo. Okay, to summarize the scenario, mother fell pregnant, she had a child, father went missing. 3 years later, father wants to get involved in the child's life. The father goes to an attorney, and the attorney writes a letter to the mother, I'm guessing, and the lawyer says father has a right to be in the child's life. What advice do I have for the mother? The child obviously does not know who the father is. It's a very difficult one. I do not want to block any father or make life hard for any mother in giving this type of advice. However, the father is a biological father, and there are 2 people in this world who potentially can have full parental rights and responsibilities over minor child by default, and that's a father and a mother. Under these circumstances, because the father made the mother pregnant and went missing, he does not have any parental rights and responsibilities regarding the child at present, because he came out of nowhere. But now he wants to be involved in the child's life. That's very important. And he has a greater right to be involved in the child's life than anybody else. Not a grandmother, stepfather, step-husband, a second husband, whatever the case may be. Therefore, under these circumstances, I would advise the parties to try to resolve this matter out of court. They might want to see a professional person, a psychologist, a psychiatrist, to determine what is best for the minor child. The child is 3 years old. The child does not know who the father is. Will it have a huge shock on the child's life to now all of a sudden find, oh, this is my dad, and who is this person? I always thought Uncle Jack was my father, or the mother's new husband, or the mother's boyfriend was the father of the child. The child always thought so. Now all of a sudden this person with this unfamiliar face that might look a bit like the child came out of nowhere and wants to be involved in the child's life. It could be traumatic for the child, and it could affect the child negatively. Therefore, these matters must be dealt with in court with caution. But at the end of the day, the father needs to be involved in the child's life. There needs to be a connection between the father and the child. That needs to happen. The question is, how will it happen? How should it happen? Unfortunately, me as a lawyer, I have some ideas. Based upon my years of experience, I have some ideas of phasing contact. But at the end of the day, it needs to be done with tact and in a manner which the child will not be prejudiced. So therefore, for example, maybe the mother can have a conversation with the child. Say, you have a father, your father went missing. These are his reasons why, whatever the case may be. Or because the child is 3 years old, it might be a bit easier to deal with it now at this time, as opposed to when the child is 16 or 17 years old. Nonetheless, I would advise the mother at least to go see a professional person and find out from this professional person how to deal with this matter. But at the end of the day, the father came to my office and told me the specific scenario. I might not have asked my attorney to write such a letter, but after a few months or a year or so, the father would have had contact. I'm certain any judge listening to the facts and looking at the matter will make a determination that contact needs to take place. The only question is, how should it take place? And generally the court will say it should be phased in contact, and after a few phased in contacts, supervised contact, maybe for a few months, going on maybe for day contacts, unsupervised, and moving from there. When the child is 6 years old, the father most probably will have overnight contact, half school holidays, and so on. I'll check online if there are any further live questions. No, there are none. Thank you very much for your time. Thank you for watching this webinar, and for the live commenter, thank you very much for your input into this. And I hope that you have a lovely day, and I hope to see you online very soon. Thank you.